Very fixed for tomorrow.
Very well.
So yes, it's fixed for tomorrow. Sorry about that.
We might ask for the permission of my Lord to exit the.
Yes, you can, please. Please go ahead. I ought to have even told you from the inception.
Thank you, my Lord.
Very well. Yes, case called. Who is in court? Is the claimant in court? Are the defendants represented? Who is in court? Is the claimant in court? Are the defendants represented by anybody? Okay, parties absent. Appearances.
My Lord, with due respect, KJ Tafa, I appear for the claimant.
AJ.
KJ. K for kilo, J for Nigeria. I mean,
Tafa.
Yes, my Lord. My appearance for the claimant.
For the claimant.
Yes.
Any other appearance? Any other appearance for the first and second defendants? Any other appearance?
They have not been coming to court.
No appearance for the first and second defendants? Malam Abdulkadir Adamu, are you for the parties? Unmute yourself. I can't hear you. I can't hear you. Check your audio. I can't hear you at all. No, you have muted yourself. Unmute yourself. Go ahead. I can't hear you. Maybe you have to. Are you using phone or a tablet? I can't hear you at all. Can you hear Mr. Malam Jim Abdulkadir Adamu? Can you hear him? Mr. Tafa, can you hear him?
My client is Saidu Mohammed Abdulkadir. I can't hear you.
You can't hear Mr. Abdulkadir Adamu?
Not Adamu, Saidu Mohammed Abdulkadir.
No,
Saidu.
there's a counsel here that is talking, but I can't hear him.
Okay.
Can you hear any other person? Ms. Malam Abdulkadir, we can't hear you. There must be something wrong with your audio. Unmute yourself and hold it if it's phone, and let's see. But can you hear me very well? You can nod and let me know. Or you write your name in the chat box. Mr. Abdulkadir Adamu. Mr. Abdulkadir Adamu. You can write your name in the chat box. Write your name in the chat box. And let me know who you are representing. Write your name. Look at the chat box here. See the chat box here. So write your name here. See who are you for? Who are you representing? For which of the parties? Just write it in the chat box because I can't hear you. You are for the first defendant. Very well. Okay, K.A. Udoje appears for the first defendant.
That's Nigerian information. Civil defense.
Who is for the second defendant? Malam Jima Abdulkadir Adamu, who are you representing? Are you representing the second defendant? Write it in the chat box. Where is Mr. K.A. Udoje? Where is Mr. K.A. Udoje, who is appearing for the first defendant? Where are you? Can I see you? Malam Abdulkadir Adamu, right, do you know the chat box? Write something there. Write who you are representing there and let me know so that I can note it. If you look at your system, you will see a chat. Who are you representing? Just write it there. I've asked that question in the chat because I can't hear you. I will proceed. Can you hear me? Just nod and let me know that you can hear so I can go very well. Here is the judgment of the court. By a general form of complaint dated 18th of December. Mr. Antafa, mute yourself, please. Mute yourself. Mute your system so that whatever anybody is saying around, I won't hear. It won't interfere with the judgment. By a general form of complaint, you have not muted yourself. I'm not saying you should not show your face, just mute your audio. By a general form of complaint dated 18 December 2018, the claimant commenced this suit against the defendant claiming the following relief. 1, a declaration that the claimant is an officer still in service of the first defendant under the employment of the second defendant and entitled to the payment of his lawful remuneration as contained in the terms of his employment with the defendant. 2, an order directing the defendants to pay the claimant his monthly salaries and allowances as Senior Inspector of Immigration from August 2011 to July 2012 as Principal Inspector of Immigration, P2, from August 2012 to date of satisfaction of the judgment being his rank on promotion. And 3 is an omnibus prayer. It is the claimant's case that he was employed by the second defendant in the service of the first defendant and serving in Taraba State, Taraba State Command of the first defendant with service numbers NIS 16732. It is his case that he was posted out of work in Ibi Town office of the first defendant in the state. He averred that while working in the service of the first defendant, he was also engaging in farming, which prompted him to take a loan together with 9 others from Intercontinental Bank. He was the chairman of the 10-member cooperative society, and a colleague of his also in the service of the first defendant was also a member of the cooperative society formed for that purpose. He averred further that he was later served with a query on the 11th of May 2011 in respect of a loan facility, and to which he responded. He continued that the loan given to him was as a result of a membership of a cooperative society. He stated that after his response to the query, the defendant in the month of August 2011, without notice to that effect, just stopped the payment of his monthly salary, which continues up to the filing of this case. He averred that he made series of complaints concerning the stoppage of his salaries, but all proved futile. He pleaded his last salary as S11 on Compass grade level 08 step 9. According to him, he was later promoted from S2 to P1II by the defendant with a circular issued in 2012. In the course of pursuing the payment of his top salary, he became sick at the period, and the other affected officer challenged the stoppage of his salary to and got judgment and has since been paid the salary owed him. It is part of his pleadings that in the year 2013, his house was burned down by hoodlums and he lost some vital documents, including his appointment letter. The defendant responded by entering conditional appearance and filing notice of preliminary objection. The first defendant filed its notice of preliminary objection on the following grounds. One, that the plaintiff failed to comply with the statutory condition precedent to the commencement of this suit, to which failure to comply with the mandatory provision of Section 1091 of the Immigration Act 2015 and Rule 23 of the National Industrial Court Civil Procedure Rules 2017 before initiating this suit. That the action is statute bad, having failed to institute the suit within the prescribed statutory period. So Learned Counsel filed a written address in support of this preliminary objection. I've reduced that into the body of the judgment. In the claimant, in response, filed a written address in opposition to the objection raised by the first defendant. In respect of that, he also argued in the written address, and I've reduced that equally into the body of the judgment. The preliminary objection filed by the second defendant is on the same grounds as that of the first defendant. In support of the objection, he filed 5-paragraph affidavits. I've reduced all the facts also in the body of this judgment and the written address. Claimant equally responded to that, and I've equally reduced all that into the body of this judgment. I will now go straight to the decision of the court. The first defendant, before then, the first defendant equally filed its defense in this suit, and he admitted that the claimant was in their employment, but that the person offered employment in the service of is one Muhammad Kumbu Saidu and not Muhammad Saidu Abubakar, who is the claimant in this case, and the person with the stated service number has since been dismissed. According to the first defendant, it encouraged the claimant to engage in farming and did not at any time encourage the claimant to obtain personal loan from the bank. It averred further that the claimant had forged the letterhead of the defendant to obtain the loan. It was equally pleaded that the claimant, without the knowledge of the defendant, took the loan from Intercontinental Bank, and they only got to know when the bank wrote to them. It was averred that there was no such cooperative society used in assessing the loan, and the bank failed to conduct due diligence to ascertain the existence of the association. According to the first defendant, the committee formed recommended that the claimant and his accomplices state the level of their involvement. Claimant responded, and the report was forwarded to the head office from Taraba, and the first defendant subsequently forwarded the report to the second defendant and recommended their dismissal. Hence, they were dismissed in 2014. It was equally averred that since the stoppage of claimant's salary, he has persistently refused to make himself available to collect his dismissal letter. The first defendant denied receipt of any personal letter or correspondence on stoppage of a claimant's salary from him. The first defendant equally averred that the payment of promotion arrears to the claimant was in error, but admits payment of the claimant's salary. It is part of the pleadings that though the claimant was promoted, the promotion was never effected to warrant payment of any form of arrears. The first defendant is not aware of the claimant's illness, and there is no correspondence that regards that between the first defendant and the claimant. According to the defendant, the claimant was never a party to the earlier suit, and the order of this court only binds parties to a suit. It was equally denied that the claimant is still an officer in service, having not reported to duty since 2014. The first defendant proceeded that the claimant is not entitled to any salary or entitlement whatsoever. Also filed along with the pleadings is a written statement on oath of its witness. The second defendant filed a 28-paragraph statement of defense, wherein it averred that the claimant's last zonal office was Wukari in Taraba State, They equally stated that the query given to the claimant was necessitated by the fraudulent acts of the claimant by misrepresentation and financial embarrassment. It was equally pleaded that the claimant and one other, without the requisite consent of the defendants, formed an illegal association through which they accessed the loan from Intercontinental Bank without the knowledge of the defendant. It is upon the failure of the claimant and others to repay the loan that the defendants got to know about the illegal acts of the claimant. It is as a result of these that the claimant and his other colleagues were queried, wherein they admitted their wrongdoing, and investigations were carried out with its report forwarded to the headquarters. It is part of its pleadings that after the query, the claimant appeared before a disciplinary panel, which recommended the dismissal of the claimant and which recommendations were made to a higher committee, which further recommended the dismissal of the claimant to the board. The board, in turn, at its meeting, sanctioned the dismissal of the claimant. According to the second defendant, the claimant was paid his salary and arrears of promotion in the month of July 2011 and has been declared eligible for promotion before his illegal acts came to the knowledge of the authorities. Claimant was then dismissed in the year 2014, bringing his case to a close. It was the position of the second defendant that the case at hand is distinguishable from the case of his other cohort, as the counsel who handled the case then were not diligent enough, and no one case can be used to expressly determine the other. It is pleaded also that the claimant action amounts to gross misconduct as provided under the PSR, that is the Public Service Rules, for which the requisite punishment is dismissal. According to the defendant, reinstating the claimant will be laying a bad example for 7 officers in the service. He then stressed that the claimant is not entitled to any of the relief sought. During trial, claimant testified for himself as CWU. He adopted his written statement on oath of 4th of March 2020 as his evidence in this case. He tendered some documents admitted in evidence and marked as Exhibit S to S6 and was cross-examined by the first defendant's counsel. During cross-examination, the defense counsel tendered one document through the claimant. The document was equally admitted in evidence and marked as Exhibit S7. The second defendant also cross-examined the CWU on the same day. There was no re-examination, after which the case of the claimant was closed. The case was adjourned for definite defense on the next adjourned date. The defendants and their counsel were absent from court without any explanation for their absence. The court therefore, pursuant to Order 38, Rule 2, Sub-Rule 4 of the Rules of this Court 2017, foreclosed the defendants from entering defense and urged the claimant to file his final written address and serve advance copies on the defendants. The case was accordingly adjourned, and at the adjourned date, the defendants were not equally represented in spite of hearing notices issued and served on them. The second defendant had filed motions to substitute its sole witness and an order to set aside the order of foreclosure, but was absent on that day, on the date fixed for the hearing of the said motions. The motions were accordingly struck out, and parties were asked to file their final written addresses. At the next adjourned date, counsel to the first defendant sought to withdraw the application to set the foreclosure order, which he had filed, to set it aside. Accordingly, the application was withdrawn and parties adopted their final written address. Sorry, just a minute. Counsel, on behalf of the claimant in the written address filed, formulated two issues. I've reduced that into the body of the judgment. I will now go straight. The first defendant equally filed its final written address. I will now go straight to the judgment of the court. After a perusal and consideration of the originating process and the accompanying documents, the notices of preliminary objection, counter affidavit, statement of defense, together with all other accompanying documents and the final written addresses of parties, have deduced and formulated two issues for the determination of this suit. The issues distilled are as follows. 1, whether the suit of the claimant against the defendant is competent before this court, and if this is answered in the affirmative, 2, whether the claimant is entitled to the relief sought. In respect of issue 1, there is no doubt that the issues raised by the defendants in the notice of preliminary objection go to the root of the action, as it raises the question of jurisdiction of this court to entertain this matter. It is tried that jurisdiction is the bedrock of all legal actions. A proceeding conducted without jurisdiction, no matter how beautifully done, is nothing but an outright nullity, as one cannot put something on nothing and expect it to stand. See the celebrated case of UAC versus McFoy. Just a minute, please, learned counsel. Just a minute. McFoy and UAC citation is UAC and McFoy citation is provided. Jurisdiction is the authority of the court to adjudicate over the questions which give rise to the cause of action. Jurisdiction is the lifeblood and bedrock of all trials. See the case of KLM Dutch Airlines versus Idehe. Citation is provided. The case of FCN and SCN, citation is equally provided. The case of Madukolo and Nkemdelim, citation is provided. Jurisdiction is also the pivotal life elixir of adjudication. Jurisdiction is sine qua non in all legal proceedings, so much so that when raised, the court has a duty to have it settled first, one way or the other, before the court proceeds to the substance of the case. So the cases of AG, Adamawa State, and AG of the Federation, citation is provided. The case of Okariaka and Samuel, citation is also provided. The case of Abubakar and others versus Nasamu and others, citation is equally provided. The Apex Court has held that an objection to jurisdiction is not a demurrer and therefore can be brought by the defendant and taken by the court without the defendant first filing his statement of defense or without filing at all. See the case of Ajayi and the Adebi, citation is provided. In the case of Bakari and the Gudipa, citation is provided. The Supreme Court held that jurisdiction is a question of law and is of two types: procedural jurisdiction and substantive jurisdiction. According to the Apex Court in that case, while procedural jurisdiction can be waived, substantive jurisdiction cannot, and it is when an objection is raised at the earliest opportunity that procedural jurisdiction is deemed not waived. In the instant case, the defendants in their individual notices of preliminary objection raised the issue of non-compliance with Section 2A of the Public Officers Protection Act, Cap P41, Law of Federation of Nigeria 2004, also known as POPA. It is crystal clear from the ipsi dixit of the application filed by the defendants that they tried to justify stoppage of claimant's salary in a statutory employment. The cross of this action on the fact that the claimant was dismissed having breached the provisions pertaining to serious misconduct, which case is a contractual matter. They accordingly invoked the provisions of POPA that the right of the claimant, even is extinguished, having been filed outside the statutory period. In the case of CL Risk and Asset Management Limited versus Ekiti State Government, citation is provided. The Apex Court held, amongst other things, that the protection afforded public officers under Section 3 of POPA does not apply to cases founded on contract or breach of contract. See also the case of Bob Manuel and AG of Rivers State. The case of the claimant having been founded on contract cannot be cut off by the period of limitation in Section 2A of POPA. It is equally plain on the originating process and the statement of facts that claimant's claims borders on payment of salary, which is in law a continuing injury. In that every day the payment of his salary becomes due and revives the cause of action. See the case of AG Bayelsa State and AG River State, Supra. It is in the light of all said above that I find that the case of the claimant is not defeated by Section 3 of the Public Officers Protection Act, I so hold. In another leg, the question of non-compliance with condition precedent, which is to give the Nigerian Immigration Service a pre-action notice as provided for by Section 109 of the Immigration Act 2015, Act number 8, hereafter called the IMMA, and compliance with administrative remedies as provided under the Public Service Rules and Guidelines. It is clear as crystal that the objection raised by the defendants on this ground is on procedural jurisdiction on which they did not waive. The first defendant is the Nigerian Immigration Service, which establishment of is governed by Section 1 of the IMMA. The second defendant, on the other hand, is the Civil Defense, Fire, Immigration and Prison Service Board, which is the creation of the Immigration and Prison Service Board Act, Cap 12, Laws of Federation of Nigeria, 2004, hereinafter called the CDFIBPB. Section 1 of that act specifically established the Board of Immigration and Prison Service, otherwise known as the Civil Defense, Fire, Immigration and Civil Service, Civil Defense, Fire, Immigration and Prison Service Board. See Section 116 of the IIMA. Just a minute. Equally, the explanatory memorandum of the IMMA provides that the Act repeals Immigration Act, Cap 2, Laws of Federation 2004, and the Passport Miscellaneous Provisions Act, Cap P1, Laws of Federation. Similarly, Section 114 of the IMMA, which is the repeal section, provides expressly thus, and I quote, the Immigration Act, Cap 2, Cap 11, Laws of Federation of Nigeria 2004, and the Passport Miscellaneous Provision Act, Cap P1, Laws of Federation of Nigeria 2004, are hereby repealed, unquote. In the case of Akingbola and FRN, citation is provided. The court held that a repeal could be by way of replacement and reenactment. It is my view that Section 114 of the IMMA repealed the old Act and the Passport Miscellaneous Provision Act. The IMMA did not, however, repeal the CDFIPB. The Supreme Court, in the case of Akintoku and LPDC, citation is provided, reasoning that where an act is intended to be repealed, it should be stated expressly in clear terms, as the court does not lean against inference of a repeal, as it is cardinal principle of law that statutes are repealed by direct provision of law except where repugnant. The CDFIPB is not expressly repealed by the enactment of IMMA, and same is not repugnant to IMMA, as they do not even provide for the same things or cover the same issues. Therefore, the CDFIPB still stands. In essence, the CDFIPB and IMA are in force, as the latter did not repeal the former. In effect, it is clear that the first and second defendants are two separate legal entities created by separate laws, I so hold. By the provisions of Section 109 of the Immigration Act, no civil action shall be commenced against the first defendant without the service of a pre-action notice on the first defendant. The provision of Section 109, 1 and 2 is as provided hereunder. I quote, no civil action shall be commenced against the service or, its authorized officers before the expiration of a period of 30 days after a written notice of intention to commence civil action shall be commenced against the service or its authorized officers. The suit shall have been served on the service by the intending plaintiff or his agent, and the notice shall clearly state A, cause of action, particulars of claim, name of the plaintiff, name of and office address of the intending plaintiff counsel, and relief which he claims. 2, the notice referred to in subsection 1 of the section, and any summons or other documents required or authorized to be served on the service under this act or any other enactment of law may be served by A, delivering it to the headquarters of the service, or B, sending it by registered post address to the service headquarters, unquote. In the same vein, Section 116 of the IMMA, which is the interpretation section, provides us, and I quote, "Board means the Civil Defense, Fire, Immigration and Prison Services Board, CDFIPB. Service means the Nigerian Immigration Service established by this act," unquote. In the case of CBN versus Registered Trustees, NBA citation is provided. The court held that in the interpretation of clear and unambiguous words in the statute, the provisions must be accorded their ordinary grammatical meaning. See also the following cases. Ugu versus Ararume citation is provided. The case of Gambo and INEC citation is equally provided. It is clear that by a combined effect of the provisions of Section 109 and 116 of the IMMA, the particular provision as regards pre-action notice relates to the service of the process on the first defendant. It does not extend to the second defendant. It is thus clear that Section 109 of IMMA only relates or applies to the first defendant. It will not avail the second defendant, as I've stated earlier. It then means that the board does not require pre-action notice under the IMMA. Equally, I've looked through the gamut of the CDFIPB and I found nothing in it relating to service of pre-action notice before the commencement of any action. Neither is there any provision for the exhaustion of any administrative remedies in it. The second defendant made reference to the guidelines for appointment, promotion, discipline, and general purposes issued by the board pursuant to its powers under Section 8 of the CDFIPB. According to the second defendant, the regulations in its part 7, pages 39 to 40, provides in paragraph 3 that appeals to the board shall be forwarded by the officer concerned through the Comptroller General of the Service and an advance copy sent to the board. The said pages 39 to 40 of the said guidelines referred to was never placed before the court, as it was missing from the guidelines placed before the court. It is not a complete document, thus not reliable, and therefore discountenanced. There is therefore no credible evidence before the court to substantiate the claim of the second defendant's assertion that the claimant ought to exhaust the administrative remedies provided in the guideline. It is thus baseless and discountenanced. I've held that the provisions of Section 109 of the IMMA applies only to the first defendant. It will not avail the second defendant. The effect of the provisions of the section is that a party must serve a pre-action notice on the first defendant before instituting any civil action in court. Service of pre-action notice is a condition precedent that should be fulfilled by a litigant before filing a matter against the first defendant. The claimant proceeded read his counter affidavit to the objection raised that he had written to the defendant and has stated that he would approach the court in those letters. There is nothing on record to support this assertion of the claimant. In the case of Akiti versus Oyekunle, citation is provided. The Apex Court held that where documentary evidence supports the depositions in an affidavit, such depositions are the correct position of what they seek to establish. Documentary evidence lends more credence to material facts deposed in an affidavit. The claimant who wants this court to believe read his counter affidavit that he made written series of complaints. That he wrote series of complaints to the defendant before coming to court, and wherein they were notified of his intention to come to court, did not exhibit any of these letters. Therefore, I do not believe this position of the claimant. I so find and hold. It is equally the contention of the claimant's counsel that the claimant's right to access the court is a constitutional right and which cannot be taken away from him by any condition precedent. I agree that the claimant has the right to access the court. However, in the case of AG Kwara State and Adeyemo, citation is provided. The Apex Court held inter alia that a condition precedent is a provision which makes the existence of a right dependent on the happening of an event. The right is conditional as opposed to an absolute right. The court further held that a condition precedent is one that delays the vesting of a right until the happening of an event. According to the court in that case, the condition must first be met, and there is no constitutional breach occurring, neither is there an infringement of the right to be heard. As such, there is no breach of the right of the claimant to approach the court. Equally, the Apex Court in the case of NCC versus Motophone, citation is provided, held that once the legislation provides for a condition precedent before a court can exercise jurisdiction, the condition must be fulfilled subject to recognized exceptions. The suit will be incompetent if the condition is not complied with. See also the cases of Wanyi versus Nikon Insurance PLC, citation is provided. The case of ProSafe Production Services Limited and OSBIR, citation is also provided. In the case of Niger Care Development Company Limited versus ASWB, the Apex Court held that a court can only invoke its judicial powers under Section 6 of the Constitution where the matter is justiciable. The courts have no competence to invoke their judicial powers where it is not justiciable. According to the court in that case, where a statute provides for a condition precedent to the filing of an action and that condition is not met, the action is not justiciable and a court of law has no jurisdiction to invoke its judicial powers. In the same vein, the Apex Court in the recent case of Cytec International Estate Limited versus Francis, citation is provided, while considering the extent of the judicial powers of the court in Section 6 of the Constitution, reiterated its earlier position that the judicial powers granted the court under Section 6 of the Constitution as amended can only be invoked where the case is justiciable. In that case, particularly pages 203 to 204, paragraphs G to B, the Supreme Court held that the scope of Section 6, subsection 6, paragraph B of the 1979 Constitution as reenacted in 1999 Constitution does not directly deal with the right of an individual to access the court. According to the court, the main objective of that section was to delimit the boundaries of separation of powers, and Section 6b was to design and describe the nature of judicial powers of the court. The court went further that it was never intended to be a catch-all or all-purpose provision to be used to determine questions of access to the court, whether by way of local standing or other issues of jurisdiction. As such, this court cannot invoke its powers under Section 6 to grant the claimant access to the court where he himself has not justified his right to approach the court by the service of pre-action notice on the first defendant. The failure of the claimant to show that he served pre-action notice on the first defendant as required by the IMMA is fatal to his case. The rules of this court equally recognizes the essence of pre-action notice, and that is why Order 3, Rule 23, Sub-Rule 1 of the Rules of this Court 2017 provides that where pre-action notice is statutorily required, photocopy of same, which was served, is to be filed along with the originating process. This was not complied with by the claimant respecting the first defendant. Therefore, I find that the case of the claimant as presently constituted is incompetent against the first defendant, having not filed along with the originating process the pre-action notice allegedly served on the first defendant as required by law. Consequently, by the powers conferred on this court by Order 3, Rule 23, Sub-Rule 2 of the Rules of this Court, supra, the name of the first defendant is struck out from this suit as the process is incompetent against it. I, however, find that the suit is competent against the second defendant. I do not find merit in the notice of preliminary objection of the second defendant. It is thus discountenanced. I so find and hold. This case would continue nevertheless in the absence of the Nigerian Immigration Service, whose name has just been struck out for procedural defect. In the case of Goldmark Nigeria Limited versus Iba Fund Company Limited, citation is provided. The Apex Court held that where the court finds that an action brought against a party is incompetent due to procedural defect raised by the party, and that party's name was struck out, leaving other necessary parties who are linked or represent the interests of a party whose name was struck out. The continuation or determination of a case after the name of a party has been struck out will not prejudice such a party. Rather, the party will be deemed to have constructive notice of the proceedings and be bound by whatever effect or affects the other parties on record. The determination of the instance suit will be continued in the absence of a Nigerian Immigration Service, that is the first defendant, as the board equally represents its interest. The board is saddled with responsibility of administering the service of the first defendant. The court will go on to determine the case in the absence of the first defendant, I so hold. With regards to issue 2, it is tried that a claimant who seeks declaratory release must rely on the strength of his own case and not on the weakness of the defendant. See the case of Takori and Matawale, citation is provided. The case of Gwebe and FBN, citation is provided. The case of D. Kibo and John, citation is also provided. The case of Dim and Enemo, citation is provided. It is the claimant's claim that he is still in the service of the board while working for the Nigerian Immigration Service. The claimant seeks to establish this fact by paragraphs 1 to 4 of his statement of facts. The defendant, the board, maintains with its paragraphs 1 and 3 of the statement of defense that the claimant is no longer in its service, as he has been dismissed since 2014. In support of the claimant's assertion, he tendered Exhibit S, which is his identity card. As I've already stated earlier in this judgment, the defendant, that is the board, has been foreclosed from entering its defense in this action. However, the Apex Court in the case of Sharing Cross ES Limited versus Umaru Adamu Enterprises Limited, citation is provided, held that a court can make use of processes filed before it to arrive at a just determination in a matter pending before it. The court is at liberty to peruse and utilize any document before it, even if the document was not produced in relation to the point of discourse before the court. That is, even if it is part of an application that was already determined or not even attended to, but is still part of the suit. The court went further to hold that a court is entitled to look into its record and make use of any document it considers relevant in resolving the issues before it in order to arrive at a just determination of a case. See also the case of Eramosele versus Federal Republic of Nigeria, citation provided. The case of Salisu versus Mobolaji, citation is also provided. It is in the light of these and the fact that the defendant already pleaded the documents in its pleadings that I would consider the documents pleaded as containing the list of documents and front-loaded on record, as well as all other documents that are part of the processes filed in this court in this matter. This is because they form part of the records before me. This is in order to arrive at the just determination of this suit. It is also noteworthy that the evidential burden of proof is not static. It shifts and oscillates constantly as the scale of evidence preponderates. See the case of Ekwezo versus Registered Trustees, SACN, citation is provided. The case of Bello and Iweka, citation is also provided. Although the primary onus is on the claimant in the instant case, who is to rely on the strength of his own case to prove his case before the court, the evidential burden shifts as the scale preponderates as civil cases are decided on the balance of probabilities. A claimant in a claim for declaratory relief, as in the instant case, has to discharge the burden of proving his case by proving his assertion with relevant, admissible, and credible evidence. Once this is done, the onus shifts to the defendant. See the case of Zodima and Ihildioha, citation is provided. In the instant case, the claimant pleads that he was employed by the defendant in the service of the Nigerian Immigration Service. He was promoted in the year 2012 and is still in service. The claimant, in support of this assertion, tendered Exhibit S, S1 to S7, which represent his payslip, promotion letter, in 2012 registration certificate of Shalom Multipurpose Cooperative Society, response to query in respect of Intercontinental Bank loan. The claimant, in my respectful view, having first considered and evaluated his evidence as supported by those documents, has discharged the burden on him in proof of his assertion that he is an employee of the defendant and still in its service. The defendant admitted that the claimant was employed by it in the service of the Nigerian Immigration Service and was promoted in the year 2012, but has been dismissed. The onus now has shifted on the defendant to prove that the claimant has been indeed dismissed from his employment and promotion, which were already admitted by the defendant. On the defendant's shoulders, therefore, rests the burden of proving the alleged dismissal. I so hold. In its bid to prove its assertion, the defendant filed its additional witness statement on oath, which exhibited a purported letter of dismissal of the claimant and an additional list of documents. Although the statement was never adopted before the defendant was foreclosed from entering its defense, I will nonetheless consider the said letter of dismissal as it forms part of the record of this court, which this court is entitled to look at as a spouse supra. See the case of Sharing Cross Limited Supra. The said letter, written on the letterhead of the defendant, dated 19th of September 2014, was addressed to the claimant. I perused the said document and I find that contrary to the approval of the board as seen in the minutes, the claimant was said to be dismissed with effect from 1st August 2012 as against 11th June 2014 approved by the board. It is right that an employer cannot issue a letter of termination or dismissal to an employee, bringing an end to his service with a backdating effect. See the case of Cosmas Inadi, a National Ear Care Center, and another citation is provided. Again, contrary to the minutes, the letter of dismissal stated that the dismissal was in line with PSR number 030, PSR rule 03041. As against rule 030402 stated in the minutes. The evidence put forward by the defendant is not reliable, cogent, and credible to substantiate their claim. They are not coherent and do not align with their pleading. Parties in this case agree that the PSR governs the employment in the instance suit. Although the defendant had pleaded and front-loaded the document titled Guidelines for Appointment, Promotion, Discipline, General Purposes issued by the defendant, which have held to be an unreliable document. This is because on the face of the said document, the guidelines, which is listed at number 10 on the list of the document, is to take effect from 15 July 2013 as stated earlier. This then means that it is the PSR that will apply since the act complained of has happened before the issuance of the guidelines. The guidelines cannot operate retrospectively unless intended. This finds credence in the Latin maxim "Lex propisit, non respisit," meaning the law looks forward and not backward. More so, where it is clear on the records before the court that the claimant was tried on the basis of serious misconduct as contained in the PSR. The defendant alleged that the act committed by the claimant amounts to serious misconduct under the PSR. The PSR in section 4, rule 03041 states thus, and I quote, rule 03041, serious misconduct is a specific act of very serious wrongdoing, an improper behavior which is inimical to the image of a service and which can be investigated and, if proven, may lead to dismissal. In the same vein, the PSR in rule 030402 listed what will amount to serious misconduct. The defendant had alleged that the act of the claimant amounts to serious financial embarrassment as stated in the PSR rule 030402H, which provides that bankruptcy, serious financial embarrassment will amount to serious misconduct. Rule 030403 of the PSR went further to state thus, and I quote, disciplinary procedure for serious misconduct shall be in accordance with Rule 030302 to 030306. It is therefore expedient that I consider the disciplinary procedure stated under Rule 030302 to 030306. 030302 provides, and I quote, As soon as a superior officer becomes dissatisfied with the behavior of any officer subordinate to him or her, it shall be his duty so to inform the officer in writing, giving details of unsatisfactory behavior, and to call upon him or her to submit within a specific time such written representation as he or she may wish to make to exculpate himself or herself from disciplinary action. After considering such written representation as the officer may make within the specified time, the superior officer shall decide whether A, the officer has exculpated himself or herself, in which case he or she shall be so informed in writing, and no further action shall be necessary, or B, the officer has not exculpated himself or herself, but it is considered that he or she should not be punished, in which case the appropriate formal letter of advice shall be issued to him or her, and he or she shall be required to acknowledge its receipt in writing, or C, the officer has not exculpated himself or herself and deserves some punishment, in which case Rule 030304 shall apply. In the instant case, it is on record that the claimant was indeed queried at the instance of a controller of the Taraba State Command, where he served as seen on the document issued as number 6 on the list of documents, and which document is titled Inquiry into Intercontinental Bank Law, dated 11th of May 2011. The claimant in response wrote Exhibit S7, already admitted in evidence, and which is dated 15th of June 2011. Rule 030303 of the PSR provides, and I quote, where a tribunal of inquiry is set up by the government and makes recommendation of a disciplinary nature on an officer, the Federal Civil Service Commission shall not act on such recommendation until it has called upon the affected officer to reply to the allegations made against him or her by the tribunal of inquiry. If the officer refuses or neglects to reply to the allegations within reasonable time or at all, the Federal Civil Service Commission or its agents shall proceed to accept and enforce the recommendations of a tribunal of inquiry and take such disciplinary action against the officer as it shall deem appropriate, unquote. Now, did the defendant comply with the provisions of the PSR in relation to alleged dismissal of the claimant? A senior staff disciplinary committee, SSDC, was alleged to have been set up by the defendant to investigate the claimant. According to the document listed as number 7 on the list of documents already referred to in this judgment, which purports to forward the recommendation of the SSDC, I perused both the forwarding letter and the document it purports to forward. There is nothing in it to show that the claimant was invited to the SSDC or that his dismissal was recommended by the SSDC, which may be regarded as a tribunal of inquiry as provided for in Rule 030303. Again, according to Rule 030303, the Federal Civil Service Commission shall request the officer to make the representation as regards the allegation against him in the recommendation of a tribunal of inquiry, failure of which the commission or its agents may proceed to dismiss the affected officer. There is no single document on record to show that this was done in the case of the claimant after the recommendation of the SSDC or that of the Civil Defense, Fire, Immigration and Prison Service Board, as seen on the document listed as number 12 on the list of documents. This is clearly in breach of the PSR, which governs both parties. At this stage, which governs the relationship between both parties. At this stage, it is important that I consider the provisions of Rule 030304, under which the claimant was allegedly dismissed. Rule 030304 states, and I quote, it shall be the duty of every officer to report any case of misconduct that comes to his or her notice to an officer superior to the officer involved. B, an officer misconduct is brought to the notice of his or her superior officer, shall be the duty of that superior officer to report it to the permanent secretary / head of extra ministerial office without delay. If he or she considers it necessary that the officer should be interdicted, such recommendation shall be made in the report. C, on receiving the report, the permanent secretary or head of extra ministerial office shall take action in accordance with Rule 030306 as appropriate, and if necessary shall interdict the officer. D, at the appropriate point in the investigation, the officer may be suspended in accordance with Rule 030405. In the instant case, the defendant had alleged that a report on the act of the claimant and the other affected officer was laid by the Controller, Taraba State Command, to the Controller General, Nigeria Immigration Service. It is on record V document which was pleaded and listed as number 9 on the list of documents and dated 18th of November 2011. In the said document, a recommendation was made that the service should take disciplinary action against the claimant and another officer for tarnishing its image and causing financial embarrassment to themselves. A recommendation for suspension or interdiction was not made against the claimant in the said report. The PSR went further in Rule 030305 to state thus, and I quote, it is represented to the Federal Civil Service, if it is represented to the Federal Civil Service Commission that an officer has been guilty of misconduct and the Commission does not consider the alleged misconduct serious enough to warrant proceeding under Rule 030306 with a view to dismissal, it may cause an investigation to be made into the matter in such a manner as it considers proper, and the officer shall be entitled to know the whole case made against him or her, and shall have adequate opportunity of making his or her defense. If as a result, the Commission decides that the allegation it may inflict on any other punishment upon the officer, such as reduction in rank, withholding or deferment of increment or otherwise. It should be noted, however, by the provisions of Rule 030102 and 030103 of the PSR that the power to discipline or dismiss is vested in the Federal Civil Service Commission. This power, excuse me, please. Excuse me, I need to drink water, please. This power may be delegated, but the power to dismiss officers on grade level 13 and below, with the exception of grade level 06 and below, is vested in the Federal Civil Service Commission. Rule 030102 and 030103 provides thus, and I quote, the power to dismiss and to exercise disciplinary control over officers in the Federal Civil Service is vested in the Federal Civil Service Commission. This power may be delegated to any member of the Commission or any officer in the Federal Civil Service, unquote, 030103. I quote, the Federal Civil Service Commission has delegated full disciplinary powers to permanent secretaries and heads of extra ministerial offices in respect of officers on salary GL 13 and below, with the exception of a power of dismissal, which has been delegated only from GL 06 and below. By the combined effect of Rule 030102 and 103 above, the powers to discipline officers on grade level 13 and below is delegated to the permanent secretaries of the or the head of the office. However, power to dismiss senior officers is vested in the Commission alone, while the power to dismiss junior officers on grade level 6 and below is delegated to the permanent secretary or the head of the office. It then will mean that in the instant case, the recommendation of a CDFIPB is not final. The recommendation has to be approved by the Federal Civil Service Commission as claimant has shown that he was a senior inspector of immigration on grade level 8, step 9, at the time of the occurrence of the act which led to his query. Failure of the board to send a recommendation of dismissal of the claimant to the Federal Civil Service for approval, being the body with the power to dismiss the claimant, is fatal. This is in clear breach of the PSR relied upon by the defendant. It should be noted that similar provisions to those in the PSR that the claimant was alleged to have breached are contained in the CDFIPB, which established the defendant and which regulates the claimant's employment. See Section 17, 18, and 19 of the said Act, but the defendant equally failed or refused to follow the procedure therein. The Apex Court in the case of Comptroller General of Customs versus Gazelle citation is provided held that it is clear from the express provision of Section 153(1)(a) and 159(1) and 160 read together with paragraph 2 of the third schedule of the 1999 Constitution as amended, that the PSR were made pursuant to the powers conferred on the Federal Civil Service Commission by the Constitution. They are accordingly a bylaw of the Constitution. The court went further to state that the PSR is not only a bylaw, but also added constitutional flavor to the employment governed thereby. As such, it is incumbent on an employer in an employment governed by the PSR to respect the rules. See also the case of Idoniboye, Obu, and NMPC citation is provided. The case of SCSC versus Laui citation is provided. The case of Shitabe and Federal Public Service Commission citation is also provided. It follows, therefore, from that it is incumbent on the defendant in this case to follow the provision of the PSR. The defendant read paragraphs 10 to 14 of the statement of defense stated that the facts leading to the issuance of query to the claimant and alleged, particularly in paragraph 14, that the claimant was given an opportunity to be heard and was tried by the Senior Staff Disciplinary Committee of the Nigerian Immigration Service in line with the guidelines for appointment, promotion, discipline, and general purposes issued. The misconduct which the claimant was alleged to have committed and to which he responded via the query occurred in the year 2009. The service became aware in 2011. The claimant was queried in the year 2010 to 2011, and judging from the document listed as number 4, 5, and 6 on the list of documents and which document form part of the records of this court, it is clear on the face of Exhibit S7 that the claimant's response to the query was received in the year 2011. It is equally clear on the face of the document listed as number 9 on the list of documents titled Report on the Intercontinental Bank Loan Fraud that investigation was said to have been conducted as far back as the year 2011 from the document that formed part of the court record. This SSDC sat in the year 2012. How then could the claimant be investigated by the SSDC in 2012, who claims to have derived its powers from a guideline that came into effect in 2013 when the SSDC already sat and tried the claimant in 2012? Where was the powers to try the claimant derived from, if I may ask? Again, the document listed as number 11 on the list of documents which forwards the recommendation for dismissal of the claimant and dated 16th October 2012 reads in one part as follows, I quote, paragraph 4, the subjects were queried by Taraba State Command and the senior officers were arraigned before the SHQ-SSDC, where it was decided that the draw be suspended and the recommendation for their dismissal was forwarded to the board. 5, find attached copies of minutes of the SHQ/SSDC meeting of October 2012 and other relevant documents for your perusal, unquote. I perused the whole document listed as number 11, and I do not find attached to it any document by the SSDC recommending dismissal of the claimant, no report of the SSDC. In fact, the only document attached to the said document is document titled Brief for Senior Staff Disciplinary Committee Meeting of the first quarter 2012, dated Wednesday, 28 March 2012. And the said document, which has no signature page or any page showing where it emanated from, the recommendation portion reads, and I quote, honorable members are hereby invited to objectively peruse through this case and arrive at a fair, just, and firm decision, unquote. A perusal of the document shows that the claimant neither appeared before it as stated in item 5 of the said document, nor is there any other document to show that the claimant appeared and was investigated before the said committee. There is equally nothing in the document to lend credence or show that the SSDC sat in October 2012 and recommended the dismissal of the claimant as suggested by the document listed as 11 on the list of documents and pleaded in paragraph 15 of the statement of defense. It is right that documents speak for themselves. See the case of Okutemi versus Airtel Networks Limited, citation is provided. The case of Ibrahim and Abdallah, citation is also provided. Again, the defendant pleaded in the statement of defense the sanctioning and approval of claimant's dismissal by the board, and a copy of the minutes was pleaded. I've equally perused and read the said document, though unsigned. I find according to it that meetings were held on the 3rd, 10th, and 11th of June 2014. I equally find that it was decided that one Danko and Kumbo be dismissed from service as recommended by BDGPC in line with the Public Service Rule 030402 with effect from 11 June 2014. First, there is nothing to show that claimant was invited to the SSDC as I've stated earlier. Secondly, there is no evidence to show that the alleged misconduct was even considered in his absence. There is therefore no document or any credible evidence on record to substantiate the alleged dismissal of the claimant. The failure of the defendant, who has the burden to prove that it actually dismissed the claimant as alleged, has failed to show that it followed the provision of the PSR and equally failed to canvass evidence to show that it indeed dismissed the claimant. It is in the light of these that I find the alleged proceedings and the resultant effect of the disciplinary action taken against the claimant in form of dismissal as a false pass. Yes, as a false pass. It is thus set aside for being in contravention of the PSR. I so find and hold. Similarly, I peruse the said letter of dismissal, the said letter of dismissal put forward by the defendant. There's nothing in it to show that the purported letter of dismissal was served on the claimant either by dispatch or any other means. The said letter was produced by the defendant, who should have the acknowledged copy of, if any. There is nothing on the said document to show that the claimant acknowledged receipt of this letter as requested on the said letter. It is safe to hold, therefore, that the claimant was never notified of any dismissal whatsoever. This makes the claim of the claimant that is still in the service believable and thus credible. I so find and hold. There are several inconsistencies and contradictions in the documentary evidence put forward by the defendant, and of which no explanation was offered by the defendant. It is tried that for inconsistencies or contradictions to be fatal to the case of a party, they must be material, and in such a situation, the evidence cannot be relied on or acted upon by the court. See the cases of Anyanwu and PDP, citation provided. The case of Obiazikwo versus Obiazikwo, citation is provided. The case of Salawu and Yusuf, citation is also provided. The contradictions in the documents pleaded by the defendant, particularly the documents forwarding the recommendation for dismissal and the accompanying attached documents, that is the record of the SSDC meeting, a minute of meeting of the board, that is the defendant, and the letter of dismissal are very material and cannot be overlooked. Therefore, this court cannot rely on them and are thus discountenanced. I so hold. Claimant read paragraph 13 of the statement of facts, averred that after he was promoted to the rank of P2 on the 27th of August 2012, the circular letter and pleaded the circular letter of promotion. The circular is admitted in evidence and matter as witness 2. The defendant read its paragraph 18 of the statement of defense, admitted the claimant's pleading in paragraph 13, and added that the claimant, prior to the knowledge of his illegal acts, has been declared eligible for promotion by the Nigerian Immigration Service, and being a senior officer, was allowed to sit for the examination. Learned counsel for the defendant objected to the admissibility of Exhibit S2. The court, however, admitted it as it is relevant to the case. The issue goes to the weight to be attached to it. See the case of Andrew, an INET citation provided. It should be noted that the defendant had admitted the promotion of the claimant and the document in paragraph 13 of his statement of defense. It is right that facts admitted need no further proof. See the case of Capital Oil and Gas Limited versus Oteri Holdings Limited citation provided. The appellate court in the case of FRN versus Kayode Beckley citation provided held that an evidence will have probative value or evidential weight if it tends to prove an issue. Exhibit S2 is a circular already admitted by the defendant, which shows that the claimant was promoted in the year 2012 to the position of P2 from S2. The document is regular on the face of it. It is also equally already admitted by the defendant, so this court will attach an evidential value to it. I so hold. Claimant v. paragraph 12 averred that he received his last salary in the month of July 2011. In support of this, he tendered Exhibit S1, the Nigerian Immigration Service pay advice for July 2011. The defendant board v. paragraph 17 of his statement of defense admits paragraph 12 of the claimant's statement of fact to the extent that he was paid his promotion arrears with his salary in the month of July. It is the law that a defendant must specifically admit or deny the allegation of fact in the claimant's pleadings. The defendant must deal specifically therewith, either admitting or denying the truth of each allegation of fact. See the case of Ifesina Chukwu versus Ifesina Chukwu. Citation is provided. The third paragraph 17 of the statement of defense stated those, and I quote, the second defendant admits paragraph 12 of the claimant's statement of facts to the extent that he was paid promotion arrears with his salary in the month of July 2011, unquote. It is obvious that the defendant did not in any way deny that money paid to the claimant in July 2011, as evidenced by Exhibit S1, was the last salary the claimant received from the defendant. An evasive answer in pleadings is no answer at all and will amount to an admission. See the case of MultiChoice Limited versus MCSN Limited GTE, citation provided. The defendant, in my view, has admitted the claim of the claimant that he is still being owed from August 2011, more so when there is nothing to show that he was ever on suspension from service, which will mean that he was not entitled to salary pending the determination of a case against him as provided under Rule 010102 of the PSR. The defendant did not plead that the claimant was suspended or interdicted. It is in the light of this that I find that the claimant is still being owed salaries from August 2011 till date. It is equally the contention of the defendant, It is also equally the contention of the defendant in its pleadings that the case of a colleague of a claimant who was dismissed with the claimant on the issue of the loan is different from the case at hand. It is its argument that each case has its own peculiarities and circumstances, and no one case can be used to expressly determine any other case. I agree that no two cases are the same. However, the claimant in the instant suit and the claimant in the other suit in Exhibit S6 suffer the same fate in the hands of the second defendant because of certain allegation of wrongdoing. I peruse the said exhibit and I find that contrary to the second defendant's assertion in paragraph 21 of his pleadings, that the counsel in the other matter handling the matter for the defendants did not file any proper process. Process was actually filed on behalf of the Nigerian Immigration Service in that case. It was only the second defendant who did not appear at all in the matter. It is a settled principle of law that a court will only depart from the decision of a court of concurrent or coordinate jurisdiction, which is persuasive where it is reached per incurium, or where the facts are different, in which case the court has a duty to distinguish the facts in both cases. See the case of Bogora and Local Government Council versus Yauta and others. Citation is provided. In the recent case of the vessel MT Sam Purpose X MTTAPTI and another versus Amajid Zing Bains, and 6 others on reported suit number CA/LA/CV/419/2012, which judgment was delivered on the 5th day of March 2021. The Court of Appeals sitting in Lagos has this to say, and I quote, "It is pertinent to state that the facts in suit number FHC/L/ES/180/7/117 Assurance Foreign Call Syndic versus MT Clover Pride and another are similar to the facts in this present case. And by the principle of sterile decisis, the trial court had a duty to follow the decision in suit number FHC/L/CS/1807/117, though only persuasive, while the trial court is bound to follow the decision of Federal High Court in suit number FHCL/L/CS/180/117, that is the Assurance Foreign Call versus MT Clover Pride and another. The trial court may also depart from its earlier decision, in which case the trial court has a duty to either distinguish the facts of the relevant cases or prove that the earlier decision was wrong." Unquote. It is in the light of the above that I refuse to depart from the decision in suit number NICN/ABJ/103/2014 as shown by Exhibit S6, as the facts therein are similar to the facts of this case. I equally find the judgment to be of sound reasoning, and I cannot depart from it. I so hold. It is well settled that for every wrong, there is a corresponding remedy. What then are the remedies available to the claimant in this case? The claimant in his Relief 1 seeks a declaration that is still in the service of the Nigerian Immigration Service under the employment of a defendant and entitled to be paid his remuneration. I've set aside the proceeding leading to the purported dismissal of the claimant and the resultant effect. I believe the claim of the claimant that is still in the service, since it has not been shown that he was notified of the purported dismissal. It is only logical that is still in service and employment of a defendant, and being a statutory employee is entitled to draw salaries as such, as he has not been dismissed and has not been shown to be under any form of suspension. It is in the light of this that I hold that Release 1 and 2 succeed. For the avoidance of doubt and for the reasons earlier given, I declare that the claim of the claimant succeeds in toto. He is to be allowed to continue in service, and he is to be paid all the arrears of his salary as an S2 and P2 officer forthwith from August 2012. I award no cost. Judgment is accordingly entered. So parties may obtain copies of this judgment tomorrow. Very well. The court will arise. Sorry, I can see Made Shola F. Olatunde for the second defendant.
Yes, my lord. I want to crave your indulgence, my lord, to enter my appearance. I was having network issues at
Just a minute. Sorry, the name again.
Olatunde.
Made Shola.
Yes, my lord. Olatunde Made Shola.
MF.
Yes,
Olatunde.
my lord. Second defendant.
Very well.
Thank you, my lord, for the judgment.
Well, like I said, you may obtain copies tomorrow from the court. The court will rise.
The court will rise.
Big congrats. Hi. Why not the judge? The judge. Big representing Samu.
Samu shi copy.
Ya kira ni nace ban ga mishi to judgment yau ba. Na
Zai warware. Dan mun tura shi lafiya ne ka tsaye.